Good evening. This is John Milburn for Laws 12067 Environmental Law. This is week 1 of term 3, 2015. This is the first time that environmental law is offered as a standalone subject at the Central Queensland University in its LLB program. I'm very pleased and complimented to be the course coordinator this term, and thank you all for joining me, some live and some viewing this recorded later. So environmental law requires an understanding of planning law as well, and one really can't effectively be an environmental lawyer without having a good grasp of planning law principles. So, of course, the main court in Queensland that deals with these issues is the Planning and Environment Court. So in many ways, the course that we're going to offer and run through is a planning and environment law course. It has with it many elements of general litigation, but it has some special aspects to it as well, and we'll talk about that during the course. Now, from time to time on UCrew, I'll provide up-to-date information and comments. The same will apply for UCrew. On Moodle, I'll put some information, and in UCrew, there'll be a lot of information. Can I just say that I am very, very pleased to see the number of people that have already embraced UCrew, and it's a great forum for having an exchange of ideas and asking questions. So thank you all of those people that have already embraced that forum. A couple of comments, or quotes rather. The first is that I really do like the quote by Justice Stephen Gadgila of the High Court of Australia. It's on the front page of Moodle. I think it bears repeating. You may go on to become great advocates for the poor and the oppressed in social justice litigation. If that is your ambition, then I do not want to dissuade you, but you should recognise that you will contribute hugely to social justice simply by being a competent and ethical lawyer solving your client's problems. My advice to you, the most inspirational and constructive thing I can say is go forth and build bridges. Now, the reason I like that quote is that it emphasises something which is very important to me in practice, and that is that we need to get the basics right. And those of you who have worked with me in the past know that I'm very keen on ensuring that what you present is correct and it's on time and it's in the right fashion. So the way in which I conduct the course will be very much as if you are in practice in environmental law. And what that means is presenting to a high standard in a professional manner and also being on time. I'm pretty strict with that as well, but more comments about that later. So if you have any questions, please feel free to unmute your microphone and ask, or use the chat facility. Very pleased, as indicated, to have a number of people online live tonight. If you do wish to join one of the sessions, please remember that I do record the session, upload it to UCrew and Moodle, and I do that via YouTube. So you will need to be aware that you could be on the internet if you participate. I don't wish to dissuade you, quite the opposite. I'm very happy to have as many people for the tutorial sessions as possible. While I'm content in speaking to camera, as it were, at the moment, my preference is that we have much more of an interactive session from now on, and tonight will be perhaps the exception in that regard. What I do plan to do is discuss the weekly topics as well as matters of interest and perhaps some additional commentary in relation to the text material. Speaking of the material on Moodle, you would have seen by now the material prepared by Dr. Lawson Smith, which is excellent, very technical, and not the way in which I propose to present the course. So that's not in any way a criticism of Dr. Smith's material. It's just that what I'll be doing is providing a different emphasis. So my emphasis is more in terms of legal practice, as if you were a practitioner now in environmental law and understanding some of the procedures and the way to actually go about practicing in law from the legal perspective rather than perhaps the scientific perspective which was adopted by Dr. Smith. Now, to do that, I need to rewrite the materials. At the moment, I've released week 1 and well advanced in the pipeline as weeks 2, 3, 4 and 5. In fact, the way I've written the material, almost all of the course is written and will be released hopefully fairly soon. When it comes to the assessment work, you will upload your assessment work through Moodle. So take your time to understand that, and if you have any questions, think about asking the question through UCrew. All right, so what's this course all about? In a nutshell, environmental law is quite different in some ways to other areas of practice because we have the interplay of the international law, federal law, state law, and all of that, for the most part, done in the context of a specialised court. In Queensland, I'm referring to either the Land Court, which deals primarily with mining matters, or more particularly the Planning and Environment Court, which of course deals with environmental disputes. And not only are we dealing with a specialised court, but we're doing so in a specialised manner of practice, where most of the decisions in the Planning and Environment Court relate to what we call merits appeals, or merits decisions, or merits reviews. A few different ways to talk about it. But merits reviews are really quite different in concept in administrative law to other areas of law where the decision making is done in a different manner. So I'll talk more about that, administrative law and merits reviews, all the way through the course. So in environmental law, the first thing to understand is that the Commonwealth does have a very important part to play in environmental law, and it does so without specific constitutional power to do so. So, of course, most of the federal laws come about as a result of the federal government enacting pursuant to one of the specific powers afforded to it by Section 51 of the Constitution. Now, when our forefathers created the Constitution, I suspect that environmental law was not even considered. It's a new area of practice, probably realistically only 40 years old. And in that sense, it's a bit like alternative dispute resolution and e-law. So this is a really new area of practice. And so there's not many cases that go back before the 80s in environmental law. It's really a new area of practice. And I'm delighted to be at this university involved in ADR and environmental law. So they're really at the cutting edge of new practice in that sense. Anyway, so the Commonwealth has power to play, has a role to play, even though it doesn't have power to do so. And in your reading, you'll see that the Commonwealth has, in a way, forced its way in there, despite constitutional challenges in the 80s, where the states consistently lost, and ultimately cooperative arrangements were made through COAG in about 92 as well. So you'll see that the Commonwealth has power, or does have a role to play, even though it doesn't have power. And of course, the state governments have a role, both in terms of legislation, but very importantly at the executive level. So much of environmental law is, as we say, process driven. And a lot of that comes about as a result of the executive exercising delegated powers given to it to undertake tasks which involve decision making and licensing, those types of things. So we've got the international law through treaties that filters down into Commonwealth law. Then we have the state law, both at the legislative branch and the executive branch. With environmental law, we also have the involvement of members of the public in a way that we just don't see in other branches of the law. So members of the public, provided they can establish standing, we'll talk more about that in about week 9, I think, If they can establish standing, which is getting their foot in the door, then they will be in a position to litigate. And standing for environmental law issues in relation to merits reviews is really quite simple, in that if you have been a submitter in relation to a proposed development, you will then have an as of right opportunity to join in the litigation that's involved in the merits review. Now, I hope I'm not talking too fast, and I hope I'm not throwing concepts at you that you haven't yet grasped, but don't worry, it'll all come together, I promise. So in environmental law, we talk about the role of members of the public in different ways. We'll also talk about some new philosophies. For example, very importantly, the precautionary principle. The precautionary principle started its existence through international treaties and agreements, going right back to, say, the Rio Convention. And from there, the precautionary principle has worked its way into law to the point now where this philosophy, this precautionary principle, is now a specific element of one element of ecologically sustainable development. So if you have a look at the definitions of ecologically sustainable development or ecological sustainability as they appear in, I think, Section 3A of the Commonwealth legislation, the Environment Protection and Biodiversity Conservation Act of 1999, or the Queensland counterpart, the Sustainable Planning Act of 2009, I think in Section 8, you'll see how the precautionary principle as a new philosophy is now entrenched in legislation, even though it started its life at a treaty level and worked its way in. Don't worry, we'll talk more about the precautionary principle later. So it's just telling you that in environmental law, there are these new philosophies that are coming in. What's also interesting about environmental law is that we need to consider how it interplays with the common law. So at common law, there really was no basis for, I don't know, judicial activism, if you like, in terms of creating environmental law. It just didn't happen in the court system. And in the court system, as we'll see in week 3, the emphasis was on enforcing common law rights. And one of those rights at common law is that essentially the landowner is free to do whatever he or she feels is appropriate with his or her land, subject only to things like not using the land in such a way as to cause a nuisance or to act negligently in the use of the land so as to create a tortious action in favour of a neighbour. So at the common law, there really wasn't any environmental law created, and that's where legislation had to come in and create essentially legislation. So environmental law is created through legislation. It's still affected by the common law, and it does affect the common law, of course, but that's how it began. And we'll talk more about that in week 3. Environmental litigation is really conducted a bit differently to standard litigation. I'll be talking primarily about the Queensland position when I talk about environmental litigation. And you've probably already picked up that the Planning and Environment Court is actually part of the Queensland District Court. I guess it's a division of the Queensland Court, District Court. Now, I practice primarily at the moment in criminal law, but one advantage that I do have, and I'm just going to switch you all to gallery view now, so if you're a bit shy, you can hide your camera, but I hope you don't, so we can see each other. One advantage that we do have, or that I have in practicing in criminal law in the district court jurisdiction, is that I'm before a lot of the judges that actually constitute the Planning and Environment Court. So I have an opportunity at judges' dinners and things of that nature being the president of the local District Law Association in particular, to have a chat to them about planning and environment court issues. And that really provides me with some additional insight, which is excellent. Okay, so I know I'm talking a lot. Are there any questions? Does anyone wish to unmute their microphone, ask a question, use the chat facility to ask a question or make a comment? Because we don't want to just hear from me the whole time. Nothing? All right, well, we'll continue. All right. Thank you for bearing with me. So during this course of this subject, we'll also talk about new developments such as the extraction of coal seam gas and the development of the Gasfields Commission, and of course explore the process of environmental impact assessment, what that means in reality, and have a look at the Zoom video by Phil Jeston in that regard, and you'll be staggered at the cost associated with preparing an environmental impact assessment and subsequent environmental impact statement. At this stage, I'm going to ask a favour, and that is if I can just change the course outline a little. I mentioned to you that I've been very busy over the last couple of weeks rewriting the materials. I'm really happy with the way it's come together, but what I would like to do is just change week 11. And in week 11, I want to make it more in line with the chapter, I think, 20 of the text, which means introducing specifically a topic on challenging environmental decision making. So week 11 will be a little bit different to what it is on Moodle. At the moment, I'll change that. And you would have noticed that the course outline on the front page of Moodle is actually different to how the course was created in the course profile when I did so over a year ago. So as I've been reading, I've been changing my thoughts about how to present the course. So if you see a bit of slight difference between what's in the front page of Moodle and embedded behind that, please go with whatever's on the front page of Moodle in terms of what we're going to do. So what that means is that this week we're talking about Introduction to Environment Law. Next week, which is based on Chapter 1 of Bates. Next week we're doing Environmental Law in Legal Context, which is Chapter 2. Week after that, Environment Protection and Common Law, Chapter 3. So just follow what's on the front page of Moodle. If I've created any difficulties or confusion, please let me know. Jane has a question. Just ask. It was asked in UCRU and I missed it, I'm sorry. And that is, would the 7th edition of the book be sufficient or have there been many changes? Actually, I did see that, Jane, and I kind of just glossed over it a bit, but I will answer the question. 7th edition will be fine. I've got to, I just don't want the publishers to be on my back saying, why are you promoting the 7th edition when we should be using the 8th edition, if you know what I mean. But the 7th edition will be fine. And the notes that I'm preparing, because they're right up to date, concentrate on recent cases, this year, if preferably, or last year. So when you see my notes, you'll see a lot of up-to-date material. So I'm sure you'll be fine, Jane. The main thing is to concentrate on the legislation at the start and then the relevant case law. As good as Bates' text is, and I think it's excellent, I still like going to the primary sources of the law, cases and legislation, and it's only after that that I go back to the text. Sometimes I go back to the text and I think, well, I read that entirely differently to the author, and then I try and reconcile that and have this little debate in my own mind. But I think you can't go too far wrong if you go to the primary sources, whether that's cases or legislation. But speaking of text material, I think the current text, Bates, is just an absolute cracker of a book. Now, it's not easy going. It's long. I appreciate that. But it is an excellent text. Where it is a little deficient, perhaps, is in terms of the practical side. It's really great for the theory, but I am concerned that at the end of this course, if you just read the material in Bates and someone asked you in an office context to file a notice of appeal against a development approval on behalf of a submitter, that you might go, how do I do that? There's nothing in Bates that tells me what to do. So with your permission, what I would like to do is deal with the theory, which is in the text, but also from time to time throughout the course, introduce a more practical flavour, because it seems to me only fair that when you complete environmental law, you're able to actually practice a little bit in environmental law. So does anyone disagree with that? Is that okay if I add to your workload by referring not only to the text but also introducing some practical skills?
Sounds good to me.
Okay, so we've got an okay there. That's great. Thank you. And much prefer. All right. Thank you, Michelle. Thank you, Cheryl. If you do want some other textbooks, I can provide you with a list, but I'll show you actually. I've got them here. So sustainable planning in Queensland that's a good text, but really I think you can probably read the legislation, and a lot of this is IDAS, the Integrated Development Assessment System. We'll talk a lot more about IDAS throughout the course. So sustainable planning in Queensland is really more a planning book, and it really deals with the integrated assessment system. So there are other ways to get that information, but that's through Federation Press. And I must say, if I was going to prescribe a second text for the course, that would probably be it. Other good ones, we've got Fisher. Now, Fisher is really good. This is Thomson Reuters. Fisher is, I suppose, if you like, a competitor to Bates. A lot of universities prescribe Fisher, a lot prescribe Bates. So that's, I think Bates is just a slightly better, but that's an excellent book. So if you wanted to go into more depth, Fisher, in Australian Environmental Laws, that's very good. What else do we have? Principles of Environmental Law. This one, I've only just got this one from the Cambridge Press. So I'm working my way through it, but it's very good. It's more at that first level, dealing with the international principles and that whole concept of how that filters its way down into the to the national level and then the state level in Queensland. So I haven't read it all, but it does look to be a good one. Now, a couple of snappy little books. This one's very good. I like this one, Dovers, and that's a policy handbook. Dovers and Hussey, that's a short book from Federation Press, so that's a good one. And then you get the real small ones. So this one by Brad Jessup. This is LexisNexis, dealing with environmental law. It's one of those little tiny books, and that, you know, I'd like this when I go to court, because if I find myself with 15 minutes spare while I'm waiting for my matter, I'll dig out one of these little books and continue to read. This one's a really good little book. This is Rachel Baird. It's Thomson Reuters, Nutshell Environmental Law. It's only tiny, but again, it's got some really good basic explanations of materials. But of all of those, my real favourite is this one. This is great. This is the Community Litigants Handbook. It's put out by the Environmental Defenders Office, and it's written in a very clear style, and it actually has some precedents to help you with the practical side of things as well. So if you were on limited funds, that's the one I'd probably recommend that you buy. Okay, so has anyone got any questions about the reading material? I've told you that my material is coming through. I'll try not to make it too long, but every week will be probably around that 25-page mark. I hope that's not completely over the top. Please give me feedback throughout the course, because this is a new course and we want to ensure that it's done the right way. I certainly do. Okay. Post that information. Okay, I can post that information, says Liz. Will do. Post books. I'll give you just that, the names of the books, the publisher, and a brief overview of what is contained in the books. Now, each week we'll talk about the problems in the reviews, so have a look at those. There's none for this week. You've got a week off, but that's the end of the ride. After that, each week you're going to have to do a lot of the talking as we review the material in the problems for the week. Do we have any problems with that? No, that's good. No dissent at all. I'll take that as an agreement. that we're all going to participate and read those weekly problems and engage in some meaningful discussion on Zoom every week. I'm really pleased that you all agreed with that. Thank you. Let's talk about the assessment overview. You have 3 pieces of assessment. The first one is due on the 14th of January. The second one on the 28th of January. I put those ridiculously close together. Part of the reason is I wanted to push them back as far as I could into the course, because I think you need to understand as much as possible about the course to do the work properly. That said, please do not leave it till the last minute. Right now, you should have read the assessment, and if you haven't read the cases or at least looked at them in some form, I'd be disappointed. I know some of you through UCrew have been doing some great work. I think Tony, Joselito, you've been finding material. You've all been great in finding material, providing some good content. There's been some really good discussions. I'm looking at UCrew now. Liz, you've been very active. Thank you very much. Joselito's provided some excellent material. Greg Barry. So all of you, thank you. And John Mendoza, Michelle, you're all into it, and that's great. So please keep up that enthusiasm. Keep sharing the information. Don't hide it. Share it. It's good karma. With the written assessments, I've given you plenty of idea of what's in the assessment. You have the assessment piece now, and I need to ask a question, so please feel free to answer this. Is anyone, all they're doing is just studying environmental law? Is that the only thing that anyone is doing? Or do I take it that people have got other things to do? Work, family, other study, other commitments? All right, lots of work. People have got work to do. So we've got things to do. Work, more subjects, 3 subjects and a baby. We've got lots and lots of things to do. All right, well, thank you very much for that. Plus corporations law. Okay, thank you for your honesty there. So what that means is that if we get close to the time of the assessment being due and you put in an extension request and you say, look, I'm really sorry, but I've got other things to do apart from that, my response will be, yeah, I know that. You know, I knew that in week 1. So why are you asking for an extension? So I'll decline your request for an extension, but I will do it with a smile. I'll do it nicely. So the point of that little statement is this. You know the date that the assignment is due. You know that the work, you know what the assignment assessment is. You know that you're going to be busy with other things. Things will get in the way of this. So even though I've said I've asked you to submit the assessment after you've had as much chance to read the material as possible, please get on with the task straight away. And look, if you can't submit the work on time, don't worry, you'll only lose 5% per day for late submission, but there is a cutoff, and you would have seen this in Moodle. And the cutoff is on the Saturday week, I won't accept any more work. And the reason for that is quite simple. I want to be in a position where I can give you some feedback in relation to the first assignment piece before the second one's due. And I've made them really close. So there won't be much time for feedback, but I've got to give you some feedback. And I can't give feedback if I'm waiting for people to submit their work. So now that we've cleared the air in that regard, you know that I am tough on extensions. By all means, try. If you've got a genuine reason and a medical certificate, don't let me dissuade you. But don't be surprised if I say no. So get your work in on time. Do that through Moodle. And the commitment I give back to you is that I will give you comprehensive feedback, I trust. And I'll do that on about the 10th day after the day of submission. So with me, all of my assessment work is due on a Thursday evening by midnight. And I then have a cut-off on the following Saturday, and I'll give you the feedback on the Sunday or the Monday after that. So 10 or 11 days after the original assessment was due. Now, is that okay for everyone? Are there any issues with that? We'll take that as a consent. We'll take that as a yes. Everyone's happy with those ground rules. All right. Assessment 1, do we have to choose our own case to assess? No. what you do is you use the Predijon case. And I'll talk about that actually. We'll talk about that right now. So the Predijon case is a case which relates to a dispute between Predijon and the Cairns Regional Council. It's a couple of years old now, but it's really good. One of the lead barristers in that case was Rod Lister QC, and on Moodle I've uploaded from a previous environmental law course that I did, I think in the business school, my discussions with Rod about the case, and he goes into a lot of detail about the tactics, the background, the circumstances involved in that dispute. So that's well worth having a look at. So to answer your question, Tony, no, it is the Predijon case. You're not selecting a case, you're actually providing me with background as to that case. You're identifying the legal issues in that case. You're telling me how to apply the law to the facts. And I've seen that my numbering in the question isn't right. That's not very good. So it goes 1, 2, 4. My apologies. Still adds up to 25. That's good. And you're applying the law to the facts. And then this is the hard part. So the first part of the assessment, worth 555, is giving me the background, telling me the legal issues, and how the judge in that case, which I think was Everson from memory, Judge Everson, applied the law to the facts. But here's the part that requires your imagination and your critical thinking. You have to come up with a hypothetical appeal. So the developer may say to you, I'm not happy with this decision. I need you to try and get this into the Court of Appeal. So you've got to tell me how you get it into the Court of Appeal, and if so, how you would do that. And I'd really like you to actually use the proper documentation. So in the task, I've asked you to identify and explain the documentation, but if you want to prepare the actual appeal, that would be an excellent way of answering the question. All right, so if there's any questions, please unmute your microphone or use the chat facility and ask a question. But I'll just give you a little bit more guidance in relation to that. With that Predijon case, the exercise that I've designed, what I want to do is test your ability to consider and interpret a decided case. So during the course of the case and the reading, you need to think about how the court dealt with an application by the developer against an adverse decision from the developer's perspective. And it was Judge Everson who heard the case in the Planning and Environment Court. And the case involved an application by way of appeal against a decision on a development application submitted to the Cairns City Council. And Mr. Predijon sought approval to develop land at Taylor Point. It's really pretty. If you have a look at some photos of this spot, it's just great. Anyway, Mr. Predijon sought an approval based on a material change of use and for a reconfiguration of a lot. That is for a development, and not only any type of development, but an impact accessible development. So you can tell me all about that as part of your assessment piece. So any questions about that brief introduction to an overview of the first assessment? No? All right. So the second assessment relates to the Ella Bay Integrated Resort proposal, and this is where we're looking at the involvement of the Coordinator General, the fact that this was declared under the Commonwealth legislation as a controlled action. It gives you some insight into the environmental impact assessment / statement regime, and it talks about the way in which submitters, or objectors if you like, are able to involve themselves in the process. So this task is designed to have a look at the way in which a proposal gets off the ground, how it's dealt with, that interaction between the Commonwealth and the state. It requires you to consider the Environment Protection and Biodiversity Conservation Act of 1999, and also you need to explain what is a concurrence agency in the context of environmental law administrative decision making. It's all good stuff. And I'm so thankful for people, I think it was you, Joselita, to find the material, and Tony and Greg were chasing it down as well. So that's great. Thank you very much. Really appreciate that. Okay, so when you come to present your assignment work, it will come as no surprise to you from what I've said already that I expect it to be presented professionally. Have a look at my sample document. It's just my take on what I think should be in an assessment. There are a lot of basics in there. You do need to reference to a high standard. We're not introduction to law now, so I expect it to be right. Use the Australian Guide to Legal Citations format. Use footnoting as prescribed, etc. Okay, so present it. Now, when you're presenting it, just bear in mind that I'm teaching this as if you are practicing in environmental law. That's the task, to try and reach that standard. And if you're practicing in environmental law, can anyone tell me what do you think is an appropriate fair hourly rate for your services? Just jump in on the chat facility if you like, or come in live. What's a fair thing to charge if you're an environmental lawyer per hour?
$500 an hour?
$500 an hour? Yep, it's not out of the ballpark at all. Joselito says the same thing. $4.99 per hour, says Tony. All right, so I'm happy to accept that as a client, and I guess for the purpose of this exercise, I am your client in many ways. I'm willing to pay $500 an hour, but what do I expect to get back in return if I'm spending $500 an hour? Come in with the chat facility. Give me a few adjectives. Liz says free. Well, that's a good one. Depends on the lawyer. Thorough, top quality work. Yep. Decent work. Correct work. Yep. I like all that. Quality work. Accurate. Good. These are really good adjectives because that's what, decisive, detailed. Thank you. That's great. I mean, that's what I expect. Now, I'm not just saying that for the sake of saying it, but bear in mind that we're presenting work as if we're presenting it to a court, to a judge. And that's what the judges want. They want it to be to the point, on topic, professionally presented. Some quick guidance: use short sentences. More than anything else, if you use short sentences, you will get your point across more accurately. Also, think about where you want to finish and, in a sense, work back. And if you work back, you're going to be working towards something once you've started the task of writing. The legal gobbledygook that seems to go on and on and on and fly off in different tangents, to my mind, probably starts when a person commences writing without actually thinking about what they're trying to achieve at the end. So if you work back and use short sentences, that might give you the best opportunity to present something in a manner that is worthy of paying $500 an hour for. Okay, so have a look at my document and just bear in mind, there's one caveat to that, it's just my take. Other course coordinators will have a totally different view of the requirements for presentation of assessment work. Okay, Liz says a lot of mediating prior to court appearances. Yes, we'll talk a lot about ADR in this course, and because I'm a nationally accredited mediator and I take ADR at this university, I'm really interested in that area. So we'll talk about that in week 11, but it will be something that's talked about as we proceed through the course. Look, let's talk about the exam for a sec. Now, with the examination, it's open book, of course. That means you can take in anything you like. If you think that you can guess what the question will be, I don't care if you write your answer or type your answer and you just walk in there bold as brass with your typed answer and you just rewrite it. Now, I'm really sorry that we have an invigilated exam in this one. I think I may change it, so don't be afraid to give me feedback to say, we don't like 3-hour invigilated exams. We think there are better ways to do it, because I would be perhaps on your side in that regard. But we have an exam, so let's start preparing for it from the outset. A few ways that you can start preparing for the exam. One way is to start writing your answers if you think you know what the question will be. Second thing is keep a folder so that if I give you some hint as to what I think is important in environmental law, you might make a note of that for the exam and think, well, there's a good chance that, he's mentioned the precautionary principle a couple of times tonight. I wonder if that'll be on the exam. So, yeah, I can't change the regime, Liz. I'm sorry. Michelle says, will that be on the exam? Yeah, it might be. Yeah, I do like ecologically sustainable development issues and the precautionary principles. So keep an eye out for that one. All right, so just keep a track or folder or something of what's going to be in the exam. Now, back in the 70s when I studied law at University of Queensland, everything was closed book and we didn't have any assessment work at all. It was just a single exam at the end of the course. Torts, for example, was one exam that covered what is now essentially Torts A and Torts B. So a lot of memory, and we used to use mnemonics, as a memory guide. It couldn't take in anything in writing. So now it's open book, much more realistic, much better. But guess what? Because it's open book, the standard has to be high to reflect that. All right, so as I mentioned, the focus of the course is one of practicing as a lawyer. I mentioned briefly I do practice as a lawyer. I practice exclusively in litigation, mostly in crime at the moment. I have a real interest in environmental law, have that connection through the district court where I get to see a lot of the planning and environment court judges and I know them, so that's good. The other things I do, I'm a member of what's called the Queensland Civil and Administrative Tribunal. And in that tribunal, the administrative law part of the tribunal is merits reviews. So part of my job is to hear merits reviews, not in environmental law, but say in blue card matters. So if someone applies for a blue card, that assessment is rejected. The person aggrieved can apply to the tribunal for an administrative merits review, and the same principles that apply in a merits review in relation to the planning and environment court litigation are applied by me and other members of the tribunal, in that our role, as you would have read, is to make the correct and preferable decision, as we say. So that's what a merits review is all about. So I have that experience as well. Course coordinator here, of course, in Introduction to Law, ADR, and also environmental law. I do a little bit of the land law work as well. And I'm a nationally accredited mediator, so I have a real interest in ADR practice. And a lot of the ADR practices that were created in the Planning and Environment Court were actually created through Peter Stilgo, and Peter is now a senior member at the Queensland Civil and Administrative Tribunal. So I've seen a lot of the way in which she works, and it's reflected in the excellent work that she did at the Planning and Environment Court level. Don't worry, I'm nearly finished. I know I've been talking for a long time, but thank you for staying with me. All right, so what I might do is I had more to talk about, but I will just perhaps leave it at this. This quote. This is going back to Introduction to Law. I mentioned I'd take that. This is my favourite quote of all. It's at page 267 of The New Lawyer. And it says, thinking like a lawyer means keeping a cool and clear head and speaking and behaving rationally when others around you may be panicking or overreacting. Think about that quote in the context of your study when it seems to be just totally overwhelming, or your work, or the other things that are going on in your life. And I guess think to yourself, I can work through this. It hurts a bit, but I can handle the pain and I can do this. And just keep that equilibrium, keep that cool head. Because when you're dealing with a massive textbook like this, there are going to be times where it feels overwhelming, and I get that. I understand that. But don't be afraid to give it a go. And remember, of course, that when it comes to the assessment piece, the first 50% is much easier to get than the second 50%, and the hardest 5% of all is the last 5%. The hardest 10% is the last 10%. So submit something. Don't be afraid of the task. Don't think it's over daunting. Just make a start, and soon enough you'll be there. All right. Look, I'm sorry that I've talked so long tonight. You've all been very patient. I'll just put you on gallery view. We'll see how many have stayed with me. Oh, lots of people have stayed with me. Now, are there any questions before we close for tonight? You can use through the chat facility, or you can just unmute your microphone. All right. Thank you. Okay. Well, appreciate your attendance. I'll stop the recording now. We'll meet next week. All the best. Bye.